You say French?
Yes, sir.
Amanda French? All right, this is cause number CR 2162, State of Texas versus Amanda Maxine French. Oh, thank you. All right, Ms. French, your name is Amanda Maxine French, is that right? Ms. French, if you'll raise your right hand, I'm going to place you under oath. Ms. French, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Ms. French, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation? Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered? Is there anything about this paperwork that you've read and signed today that you do not understand? Mr. Manning, do you believe Ms. French to be competent today?
Yes, sir.
Have you explained to her her legal constitutional rights and also the advantages and disadvantages of a deferred adjudication plea?
We've gone over this.
No, I haven't. All right, Ms. French, you were originally charged with a second-degree felony offense of aggravated assault with a deadly weapon. However, I see that the plea agreement in this case would be that you would plead guilty to a Class A misdemeanor offense of deadly conduct in exchange for the state's recommendation that a finding of guilt be deferred in your case and you be placed on 1 year of community supervision. A Class A misdemeanor offense of deadly conduct carries a range of punishment of confinement in the Van Zandt County Jail for up to 1 year and a $4,000 fine. That means if the court accepts the plea agreement today, places you on deferred community supervision, if you violate the terms and condition of that community supervision and the state produces evidence of the same, the court could adjudicate your guilt. That means convict you of that Class A misdemeanor and revoke your community supervision and assess your punishment anywhere from 0 days up to 365 days confinement in the jail. Do you understand that? Understanding that range of punishment in the plea agreement, do you still want to go forward with this plea? Ms. French, how do you plead to the Class A misdemeanor offense of deadly conduct? Are you pleading guilty to that crime because you committed that crime? Has anyone threatened, forced, or pressured you to plead guilty today? All right, the court accepts the defendant's plea of guilt. Mr. Manning, any objection to states one, the stipulation of evidence?
Judge, I don't believe we have a objection. I just want to ask, I don't know if it says indictment or if it says featuring a lesser included. We just make sure that it reflects the record. She is pleading true to lesser included.
Yeah, it doesn't say either. It doesn't say lesser included. It just says deadly conduct, Class A misdemeanor.
That's fine.
Yeah, it says degree of offense, Class A misdemeanor, offense, deadly conduct.
Then we have no objection to stipulation of evidence.
All right, then State's Exhibit 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Notify the court that in fact, the statement in this case, the statement also notes that this Frank was originally arrested for an offense of deadly conduct. The state reviewed some of the evidence, indicted it as assault. On discussion with Mr. Manning, state doesn't believe it's in the best interest of justice to proceed under the lesser included.
Thank you, Mr. Dwight. All right, the court will review the victim impact statement and the evidence. Anything further from the defense at this time?
Nothing but that.
What about the weapon in this case? Was it seized? There's no destruction order for that weapon in the paperwork.
That wasn't part of the.
I think it is. You need to. I want to destroy it. I want to see. I mean, if we seize it, I want to. She's gonna be pulling it out on a child exchange. She don't need that. I don't care if it's very or not. She's getting access to it and she's pulling it out, threatening to shoot anything. She doesn't even have a gun.
Judge, if I may, when I met with my last week, we went over in depth each and every aspect of discovery.
Okay, so, all right, we're back on the record, CR 2162, State of Texas versus Amanda Maxine French. Court has reviewed the evidence. Court finds that there is sufficient evidence to convict Ms. French of this offense. Court has indicated to counsel that it has concerns with Ms. French retaining the firearm used in the commission of this crime. And the court is going to order that the firearm seized by the Van Zandt County Sheriff's Office or other law enforcement agency be destroyed. And with that being a condition of the plea agreement, Ms. French, you still want to move forward with this plea agreement? You can roll your eyes all you want. I don't care. I don't care. Ms. French, I don't care. I don't care. You can be the victim here if you want, and you can withdraw your plea. We can go to trial. You can do whatever you want. I don't care.
Yes, sir.
And you understand you're pleading guilty to deadly conduct. And it tells me in here that you pulled a firearm out at the exchange of a child, or what was supposed to be the exchange of a child. You understand that?
I understand what the victim is.
Well, I'm not talking about the victim impact statement. I'm talking about the police report that you and your attorney have given me to review that says that you committed this offense. That's what I'm reviewing. Yeah, I've reviewed this, but I'm reading this.
As I said earlier on, there are certain things that are in the police report that are verifiable and untrue, that are incorrect, that are shown on the victim's home video statement that he gave with his own cell phone video footage. So while we understand that she is being true to deadly conduct, as I mentioned before, there is affirmative evidence that shows that certain parts of that police report are incorrect.
But what is true is that Ms. French did wield a gun and she is pleading guilty to that offense today. That's true.
That's correct.
And that's why I want the gun destroyed.
That's all.
And I have no problem with that.
Well, don't roll your eyes at me next time, and I won't think you have a problem with it. It's gonna be a long year for you, I can already tell. If you make it that far. All right, the court's going to follow the plea agreement, place Ms. French on deferred community supervision for a period of 1 year for the Class A misdemeanor offense of deadly conduct. Court orders her to pay $1,000 fine, $270 court costs, $785 reimbursement fees, and the court orders the destruction of the weapon seized in this offense. Ms. French, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. All right, Ms. French, come forward to be fingerprinted with the deputy. Love y'all. Mr. Woodward, if you want this victim impact statement back, so you can return it to, I did.
Yes.
Robert Schultz, CR 21310. All right, Mr. Schultz, the court has reviewed your request for court-appointed attorney. The court finds that you have sufficient assets that disqualify you from a court-appointed attorney. So are you going to hire an attorney to represent yourself? If I give you some time, do you believe you can hire someone? And do you believe that you could have them hired by November 9th? All right, I'll set you for arraignment on November 30th. And I expect you to have your attorney with you on that day if that's what you're gonna do. All right, let me give you a notice of setting here. You sign the yellow copy. After that, I want you to report over here through this door for the pretrial release department. Um, Schultz, Robert Schultz, CR 21-241. It's this bottom one right there if you want, that very bottom one. And it'll be 11:30 for arraignment and hire attorney. Yes, he needs to go to pretrial release. This is Mr. Schultz. Mr. Schultz, I need you to make a payment today to Mr. Waddell. All right, Ms. Bryant, come on up. This is a sanctions court hearing, so you don't have to put it on the record if you want. All right, Ms. Bryant, this is a sanctions court hearing. Tell me what's going on with your interlock device.
I have it fixed. So, 2 months ago, my car blew up and I sent it over to the high next door and they said it's gonna take about 2 to 3 weeks to look at it. It ended up taking longer because some of the crack COVID, so it had to get pushed back. My sister's boyfriend ended up going and picking it up for me because he is not looking at the TV. I think got the whole
So your car is operable now. What's the issue with the interlock? Do you have an issue with the interlock device?
No, sir, not any longer. If the reason why it's in service lockout is because they had it over there at the, over at the high store and over in TV when they were fixing the motors.
So your interlock's operational today?
Yes, sir. And it's been working ever since the last time I have seen the Stephanie, going by, officer, and that was,
When was that?
the 7th of last month.
Of September?
Yes, sir.
You want to talk to her about this? You want to talk to her about that? She says the car is working, interlock's working. Okay. All right. Come back here and see Miss Burns. Okay, so on 11:30 with Leonard. But he's only going to have listed one defendant, and Mr. Handier represents both. So we need to get Leonard the information for the other defendant that Mr. Handier was showing. Right, that's what I'm saying. Mhm. Yes, Yandis, Omar, Perez Hidalgo. Yes, he said he thinks both of them. Do you want me to keep, do we want to add also this, Dave Donovan? Mr. Herrera? It's just an arraignment, so I mean, we could. Yeah. Oh, you don't know? I'm very good. All right, okay, I'll let you know this. Would you do me a favor? These. Here it says there is a language barrier. So if you'll ask him if he'll do the arraignment on Jose Herrera, we'll do all of that. Okay, thanks. Mr. Manning. So you took Mr. Herrera?
Sorry.
You took Mr. Herrera?
Yes, I was getting ready to go speak with him.
Okay, so. Glad I took that weapon away from him. That's not good. Mr. Bundrick, if you'll come forward, sir. This will be CR 16-630, CR 18-391, State versus Logan Dwayne Bundrick. We doing please today?
That's correct.
You know, I forgot Mr. Manning has another plea. We do not need to work him. Hey, I forgot that you have Mario Martinez too. So that get Jeff done, but if you want to, we'll do Mario, however you want to do it. She'll get that all squared away back there. Take him in custody, that's what you want. Thank you. All right, Mr. Bundrick, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. Your name is Logan Dwayne Bundrick, is that right? Mr. Bundrick, in CR 16-630, you appeared before the court on the charge of stalking, and you appeared on June 15th of 2017. You pled guilty to that offense. The court heard the evidence, found there was enough evidence to convict you, but the court followed a plea agreement in your case. The court deferred a finding of guilt, placed you on community supervision for 4 years. It was during that period of 4 years that the state filed its motion to adjudicate your guilt and revoke your community supervision. They filed that September 7th of 2017. In this case, you're represented by the Honorable Jeff White. Have you had enough time to review this motion to adjudicate with Mr. White? Feel like you've had enough time to speak with him, to have all your legal questions answered? Mr. White, does your client waive the formal reading of the state's motion to adjudicate? Is it his intent to plead true to counts 1 through 5? Mr. Bundrick, in CR 18391, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle that carries a range of punishment of not less than 2 years, or more than 10 years, and a fine not to exceed $10,000. Do you understand that full range of punishment? I see the plea agreement in each one of these cases is that you're going to plead true, you're also going to plead guilty, and the states are recommending that you remain on community supervision in one charge, that you be placed on community supervision in the other, with a sentence of 8 years confinement in the Texas Department of Criminal Justice, with that being suspended and you receiving probation for 5 years. In addition to that, you would have your financial obligations, of fine, court costs, and restitution and reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
Mr. White, do you believe Mr. Bundrick to be competent today? Mr. Bundrick, then I'm going to ask you at this time, how do you plead to counts 1 through 5 as alleged in the state's motion? Are those counts true or not true? And are you pleading true to those because the conduct or behavior alleged in the counts are true? Are you pleading true to these things because it is true? And has anyone threatened, forced, or pressured you to plead true to these counts today? With regards to the evading arrest or detention with a vehicle, how do you plead to that charge? Are you pleading guilty because you are guilty of committing the offense of evading arrest or detention? You're not? Are you pleading guilty because you are guilty of committing the offense of evading arrest or detention with a vehicle? Has anyone threatened, forced, or pressured you to plead guilty to that charge? All right, the court will accept the defendant's pleas of true in CR 16630 and the defendant's plea of guilt in CR 18391. Mr. White, any objection to states A and states 1 respectively?
No objection.
All right, states A is admitted and states 1 is also admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? So somebody kind of give me an idea of why Mr. Bundrick, why he should stay on, why the court should go any further in reviewing the plea agreement and approving that, since he's already been on probation and he didn't show up and didn't do anything. Why is he getting a second bite at the apple and he's got a new charge?
Well, Your Honor, I think I'd like to address that. First thing, as you would notice, that all these allegations are quite some time. I believe Mr. Bundrick has made a change in his life. He has told me that he does not want to continue down the path that some of his relatives have gone through. He had an offer that many people would have taken because it was just too easy not to take it. We were offered 2 years, and we all know that probably would never even go down to the penitentiary. Probably grow an extension here. And might be out after Christmas. I've told him that I'm taking this offer, and he wanted to take the harder offer. That come around Easter, he may not be real happy. But he assures me this is the way he wants to do it. And I think that you ought to go along with this with Judge, because he's actually trying to do the harder right than the easier wrong.
State,
I'm counting on it.
you agree?
Judge, we did in fact offer him 2 years in prison. Mr. White came to me and asked for, I agree, this would be quite a bit harder for Mr. Bundrick than the state's offer. Our offer on this is fairly low because all of this happened 3 or 4 years ago. Mr. Bundrick has been living here in Benson County for the last 4 years, and no one has ever done anything about this. Mr. Bundrick turned himself in, he's cooperated with Mr. White and the sheriff's office in getting to this point. At this point, I'm willing to give him another opportunity. I asked Mr. White, he has explained to Mr. Bundrick that if he takes this and he does not succeed, he is going to prison for 8 years, which is far in advance of the 2 years that we offered him today as a result of this. If he's willing to give this an opportunity, he's telling Mr. White that he's made changes in his life, and he'd like to be a productive member of society. I'm willing to give him those opportunities.
Mr. Bundrick, I want to hear from you. Tell me why I should do this.
I mean, 3 years ago, I took a whole lot All I want to do is my kids grow up, I want to provide, I want to take care of all my problems. So, I think that's something that I know. I'm to be a man for, take care of.
What's caused that change for you as opposed to 2017?
I lost a cousin of mine, the UTV. And ever since I changed my life, everything, I lost my grandpa 6 months later. I didn't want to live it. I watched my dad, I watched my brother, I watched a lot of my.
State will need you to sign the certificate of discovery.
Did I miss any other?
No, I think that's it. All right. Of course, reviewed the evidence in CR 18391. Court's going to find that Mr. Logan Bundrick has violated the terms and conditions of his community supervision. Court's going to follow the plea agreement in each case. Mr. Bundrick, I'm going to extend you a line of credit. All right, so I hope you take advantage of it. CR 16330, the court finds the violations to be true. Court will adjudicate his guilt for the third-degree felony offense of stalking. Court will assess his sentence at 8 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will suspend that sentence and place Mr. Bundrick on community supervision for a period of 5 years and order him to pay the balance of his financial obligations. In CR 18391, court finds sufficient evidence to convict Mr. Bundrick of this offense of evading arrest or detention with a vehicle. The court assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence for 5 years, place him on community supervision, order him to pay a fine of $5,000 with the fine to be paid at the time of the plea. Is he paying that today? I appreciate that, Mr. Bundrick. Court will also order him to pay court costs of $290, reimbursement fees at $35. Court will order the sentence in CR 18391 to be concurrent with the sentence in CR 16630. All right, Mr. Bundrick, you hereby remanded to the custody of the Van Zant County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with the bailiff. I appreciate what you say, but I'll appreciate even more what you do. Okay? Is that all you have, Mr. White? Thanks, sir, and I appreciate your argument. You ready, Mr. Martinez?
Is it for, I don't know if you're from.
He's not.
Okay.
I've been watching. He's probably gonna log in any minute, but
Then it's over.
Mario Martinez, CR 21-178. Mr. Martinez, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. Your name is Mario Martinez, is that right? Mr. Martinez, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you? Feel like you've had enough time to review your case with him and have all your questions answered? Is there anything about this paperwork, Mr. Martinez, that you've read and signed that you do not understand? Mr. Manning, do you believe your client to be competent today? And you have discussed with him his legal and constitutional rights, and have you also explained to him the advantages and disadvantages of a deferred plea?
I have,
And you believe he understands those?
he does.
All right, Mr. Martinez, you are charged by indictment with a third-degree felony offense of tampering or fabricating with physical evidence. The range of punishment for a third-degree felony is confinement in the Texas Department of Criminal Justice prison for not less than 2 years or more than 10 years, and a fine not to exceed $10,000. Court sees that your plea agreement is that you would plead guilty to that charge in exchange for the state's recommendation that a finding of guilt be deferred in your case and you be placed on community supervision for 3 years. If I approve this agreement and place you on probation, what that means is during that 3 years, if you violate any of the terms of your community supervision, then the court, the state could file a motion to revoke your community supervision, to adjudicate your guilt, bring you back for a hearing. And if the state proves that to the court could revoke your community supervision and put you in prison anywhere between 2 years and 10 years. Do you understand that? Understanding that range of punishment and the recommendation and what could happen, do you still want to go forward? All right, court will then ask you, Mr. Martinez, how do you plead to tampering or fabricating with physical evidence? And are you pleading guilty to that charge because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? All right, court will accept the defendant's plea of guilt. Mr. Manning, any objection to states one?
No.
All right, states one is admitted and the court takes judicial notice of Mr. Martinez's judicial confession. Anything further from the state? From the defense? All right, court will find that there is sufficient evidence to convict Mr. Martinez of tampering or fabricating physical evidence. Court will follow the plea agreement in this case. Court defers a finding of guilt, places Mr. Martinez on 3 years community supervision, orders him to pay a $2,500 fine, $290 court cost, $785 reimbursement fees. Mr. Martinez, have you ever been on probation before? It's not good if you have to think about it. Was it misdemeanor or felony? I see here that you probably would have had a misdemeanor charge if you wouldn't have found the marijuana outside the, you took a misdemeanor and made it, you did the prosecutor's jobs for them. You made your misdemeanor crime a felony. So this carries a much stiffer sentence if you are not successful on your probation. I hope you understand that. In other words, I take it very serious, you being placed on probation. And if you stand here and tell me that this is your agreement and this is what you're going to do, then I expect you to do it. And if you don't take it serious, I want you to know that I do. Okay. All right, Mr. Martinez, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward with my bailiff here to be fingerprinted. After that time, you'll report through this door to probation. All right, and I do believe I have my. Yes. Well, no, because I mean, they'll see on the computer, right? You. All right, Mr. Cabales, I need just one moment to set up a computer and then we'll be ready to move forward. Can't hear you. Need me to join it? Need me to pull you in? Okay. So I've already joined. And who is this, Miss Tabraham?
Good morning, Your Honor. Your Honor.
Good morning, sir. Cabrera. Okay. I believe you unmute him, Patty. With the headphones on, I believe you unmute.
See.
Okay. Hopefully that won't give us a feedback loop. All right, Corrales, you'll raise your right hand. Sir, do you solemnly swear or affirm that you will the translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right, if you'll state your name and your license number. All right, this is cause number CR 21207, State versus Carlos Cabrera Alonso and Mr. Hidea. We are set for pretrial today. Do you have any contested pretrial motions to bring before the court?
No, Your Honor.
All right, so what I would do is I would then set the next setting to be a docket call, and it would be between now and then that I would expect you and the state to negotiate if you seek to do that. And if there's no negotiation and no plea agreement, then on the docket call date, I expect either hear, yes, we're going to plea, or no, we're going to set it for a trial.
Yes, Your Honor, I just sent an email to the prosecutor to discuss both cases.
Okay. And let's see, I would set this for a docket call hearing. Are you available on November 30th?
Yes, Your Honor.
Okay, we'll set Mr. Cabrera Alonso then for docket call on November 30th. And that will be at 9. Well, let me check with my interpreter to see if he knows if one time or the other would be better.
Yes, Judge.
And Mr. Is it open? Okay, let's set it, let's do 10 a.m. 10 a.m. That way that gives my court a chance to get going before we bring the interpreter in.
Yes, Your Honor.
And Mr. Perales, what I'm going to do, there's going to be 2 other individuals after Mr. Cabrera that are going to need the same setting. So we'll just do all of them at 10 a.m. All right, so Mr. India, are you a Spanish speaker as well?
No, Your Honor, but I'll have my paralegal with me that does speak Spanish.
Okay, so if there is, if you do reach a plea agreement and we need the assistance of an interpreter to go over those paperwork, we can make one available with Mr. Perales, but we wouldn't do that right at 10 o'clock at the time of the court hearing. That we would have to set that up to do that in advance. So I don't want you to want to do a plea and then us at 10 o'clock have several pleas to do, because we wouldn't be able to get it all done. So we'd have to make arrangements to have that done before. Either you would do that, or you would contact the court and we would contact Mr. Perales and his office to see when they may be available.
Yes, Judge, for the purposes of the paperwork, I'll provide my own interpreter for the client.
Okay, thank you, sir. I appreciate that.
Thank
All
you.
If there's no other issues in this case, then we will be adjourned, Mr. Cabrera's case, and we will see him back on November 30th at 10 a.m. Yes, ma'am. Yandes Perez Hidalgo. And Mr. Perales, did Ms. Tabraham get you this information for this case for your record? Okay. I think it causes feedback. Are you able to hear them at all?
Are you asking me, Your Honor?
He's unmuted.
It creates a feedback loop in the courtroom. But you are able to audibly hear the defendant in the Spanish channel, is that correct? Can you hear him? Let's take a second to figure this Mr. Prowse, our settings are all the same as they typically are, but I don't think I should hear him when he's speaking on the Spanish channel, though. Yeah, I'm on the English.
Mr. Prowse, did you hear it?
Switch over to the Spanish channel and speak to him for a moment and see. Well, he shouldn't have to speak in that microphone. If he's got the headphones on, he shouldn't have to speak in the microphone. It should go through this mic. Is it the setting on the laptop not picking up the plug-in headphones? That would be my guess as to why he's not picking them up, is that the computer's not recognizing his headphones. We unplug and plug back in. And when it pops up, what are the options?
And it says Mac.
Unmute it again and see.
I think that's gonna.
All right, let's just do it this way. Let's just do it with a pause.
What if we
Just unplug it and we'll just do it. We'll do it without the Spanish channel, Leonard. All right, so we're gonna have to pause after every time we say something so that the translator can translate. All right, this is cause number CR 21233, State versus Yandis Omar Perez Hidalgo. Mr. Perales, he doesn't have the headphones on anymore. Can he still hear through the headphones? No, you're gonna have to leave the Spanish channel and we're just gonna do it the old school way. I have disabled, it's off. This is English. This is off. You have to turn your Spanish channel off on the globe. You have to go to the globe and say off.
And Your Honor, if needs be, my paralegal can interpret, if that's easier. I'm
Well,
not
I
sure.
can't, I can't, I have to have a licensed court interpreter for it to be official and on the record. Let's try it this way. How about now, Mr. Prowse?
Yes, now I can hear. Yeah, you have to end it. That's right.
All right.
Ok, empieza la audiencia. Este es el número de caso CR 21333. El caso de Yandis Omar Pérez Hidalgo.
We are set for pre-trial today. Mr. India, do you have any announcements? Are there any contested motions for the defendant?
There are no contested motions, Your Honor.
La audiencia de hoy es una audiencia intermedia antes de juicio. Ya se ha anunciado por el abogado Henday que ya no hay otras peticiones que se tienen que resolver antes de juicio.
There being no contested motions, the court will set Mr. Perez for pre-trial set or docket call setting on November 30th at 10 a.m.
Entonces, ya que no hay otros asuntos que se tienen que resolver antes de juicio, se va a reprogramar este caso, señor, para el día 30 de noviembre a las 10 de la mañana, para que esté aquí, para que tenga esa audiencia final.
And Mr. Perez will need to sign the notice of appearance, and then he'll need to report to pre-trial release over here through this door.
Señor Pérez, después que firme eso, pase allí a donde está el juez, donde le está indicando, ahí atrás, para que hable con el departamento siga la carcelera.
Where's Mr. Manning? All right, thank you, Mr. Hidalgo. I think that concludes your business today, correct?
Yes, sir, and I apologize for being late, Your Honor. I got stuck in the other counties.
I appreciate you being here.
Thank you.
Where's Yes, yes. Yeah, he needs to go back there also.
Let's fix it.
All right, Mr. Perez, if we give you too much, you just tell me and we'll. Where's Mr. Manning at? Is he outside? Mr. Perez, if you want to introduce yourself to Mr. Jose Guadalupe Rivera Herrera, go ahead.
Señor José Guadalupe Rivera Herrera, el que está hablando en español es el intérprete. Yo le voy a interpretar esta audiencia al español para usted, para que usted entienda lo que se está diciendo. ¿Pudo entender y escuchar bien? ¿Sí? Ok, gracias. Ok, Judge, I've done it.
All right, Mr. Herrera is set for arraignment today and has been appointed the Honorable Jonathan Manning to represent him as an attorney. Go ahead with that.
Muy bien, esta audiencia del señor Herrera, Herrera es para informarle de los cargos en su contra y ya le hemos asignado a Jonathan Manning, es un abogado, para que represente al señor José Guadalupe Herrera.
Mr. Manning, does your client waive the formal requirements of arraignment?
Yes,
Is his name spelled correctly in the indictment?
it is.
Muy bien, y ahora el señor Manning ha renunciado la lectura formal de los cargos aquí en audiencia pública y confirma que el nombre y apellido de usted está correcto en los papeles.
And does he enter a plea of not guilty into the record?
Yes, please, not guilty.
All right, the court will enter his plea of not guilty into the record.
Y el señor Manning ha constado una contestación de no culpable al cargo para el señor Guadalupe Herrera y el juez acepta esta contestación para propósitos de esta audiencia.
Mr. Manning, are you available for a pretrial hearing on November 30th?
Está checando si el día 30 de noviembre está el abogado disponible para tener esa audiencia la próxima de usted, señor.
You said the 30th?
Yes, sir.
I am available.
All right, court would set this hearing for a pretrial on November 30th at 10 a.m.
Entonces, así se va a hacer. La próxima audiencia de usted, señor, va a ser el día 30 de noviembre a las 10 de la mañana para que esté aquí en esa fecha y hora. Okay.
And if you'll inform Mr. Herrera that he needs to sign the notice of setting, and then he'll need to report to the pretrial release department.
Señor, firme allí, le van a dar un documento para que lo firme, es confirmando la próxima audiencia que le informaron. Luego después pase ahí donde está indicando el juez para que hable con la oficina para las personas que están en libertad provisional.
And will you ask him if he has any questions?
¿Tiene alguna pregunta? No lo oí. No questions.
Okay. Yeah, he needs to sign the notice of setting and go and meet with pretrial.
¿Ya lo firmó o no se lo dieron? Is he going to be given that notice?
Yes, the attorney's filling it out and we'll.
Okay.
to it.
Sí, el abogado se lo va a llenar. Puede pasar ahí, señor, donde le indique.
All right, thank you, Mr. Perales. I appreciate you. I think that's all we need you for today. And on the 30th at those 10 a.m. settings, I would expect those to all be relatively short. Should take more than 30 minutes for all three combined. So you can schedule your time. So if I could get you from 10 to 10:30, I should be good to go.
All right, Judge, I'll do that. Thank you.
Yeah, and I'll try to figure out what's going on with our headset because we haven't
Yeah.
experienced that, but it's obviously not working. So,
Have Patty call us and then we can do some tests before that.
okay, will do. Yes, sir.
Thank you, Judge. Bye-bye.
Thank you. Appreciate it. All right, Mr. Platten, you ready? Mr. Watson, CR 18-113.
Judge, I think this is all gotten out of order.
Here, we'll need that stuff filled out, like what the crime is, what the charge is, because that's what he's being admonished of. Thank you for taking that, Mr. Manning.
No, Judge. Okay. Oh, may have been, Richardson. I believe he's been reset.
I think I've seen the Caleb Richardson.
I believe that was on business, might be excused.
We're extending meeting with that.
All right, Mr. Watson, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, Mr. Watson, in cause number 2021-389, you're charged by information with a Class B misdemeanor offense of driving while intoxicated that carries a range of punishment of not less than, or from 0 days up to 180 days, and a fine not to exceed $2,000. You understand that full range of punishment? I see the plea agreement in this case would be that you would plead guilty to that charge in exchange for the state's recommendation that your punishment be assessed at the maximum 180 days confinement in the county jail, with that sentence being suspended and you being placed on probation for 18 months, you receiving a $1,000 fine, $60 restitution, $270 court costs, $80 reimbursement fees. And as a condition of your community supervision, you'd be ordered to do 9 days in jail, to serve 9 days in jail as a condition, with you serving that as agreed on some certain weekends in November. Is that your understanding of the plea agreement? And in this case, you're represented by your attorney, Mr. Eric Platt. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him, have all your questions answered? Is there anything about the paperwork that you've read today and signed that you do not understand? Mr. Platt, do you believe Mr. Watson to be competent today? You explained to him his legal and constitutional rights?
Yes.
All right, Mr. Watson, understanding the range of punishment and the plea agreement, how do you plead to the charge of driving while intoxicated, Class B misdemeanor? Are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? All right, court accepts the defendant's plea of guilt. Mr. Platt, any objection to State's Exhibit 1 stipulation of evidence? States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? Go ahead. Was there a blood lab in this case? All I have is an offense report and the statutory warning and the report saying that he gave blood, but I don't have the lab report. You offer that as State's Exhibit 2? Any objection, States 2? All right, States 2, the blood lab report will be admitted. All right, Mr. Watson, the court has reviewed the evidence, and based on the evidence, the court will find that there is sufficient evidence to convict you of this offense. Court will follow your plea agreement. Court hereby convicts you of driving while intoxicated, Class B misdemeanor, assesses your punishment at 180 days confinement in the county jail. Court will suspend that sentence, place you on probation for 18 months, order you to pay a $1,000 fine, $60 restitution, $270 court costs, $80 reimbursement fee. Court will order you to serve 9 days in jail as a condition of your community supervision during the periods outlined in Exhibit A, the special order for commitment to jail. Court this day is also granting the state's motion to withdraw the state's motion to adjudicate. Court has signed that order. Court has also signed the amendment to the conditions of community supervision in CR 18-113 to include additional costs of court and the defendant being ordered to an extended period of probation for a period of 2 years, beginning June 21st, 2021 and expiring June 20th, 2023. Court is also ordering the defendant to submit to a period of detention in the Van Zandt County Jail to serve a term of imprisonment of 30 days with credit for time served on the dates outlined. Mr. Watson, Mr. Platten has done you a good job and gotten you another bite at the apple on probation. Not very many people are able to do that. So you better take advantage of that opportunity. Okay, next time in here, not gonna go like this. Understand? All right, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Correction Department. Come forward to be fingerprinted with a deputy and then report to probation with these officers. Thanks, sir. Appreciate it. Good to see you. Okay, let's see. Caught up here, I'm way behind. 30. All right, the court is going to have the following names called: Ryan Augustine. For the record, Julie Mullen, CR 21-300-1719, release of surety has already been granted, so there's a warrant on that case. Court is going to have the name David Lee Phillips called. Courtney Ray Schmucker. What was Mr. Manning saying about Caleb Richardson? CR.
We've already used that then, I believe, for October 26th. Neither one of us knew I was on the docket today.
Do you know what he's set for?
Your Honor, I believe it was status regarding the state still trying to locate some of the eyewitnesses to the call.
Okay. Martin Perez. Do you have any record of him being here with Mr. Schmidt?
No, honestly, I'll get.
All the way. Do you have anything on page 8, very top with Richard? I don't show anything on him.
Just let you call the name.
Okay. All right, if you'll call those names loudly, distinctly 3 times.
No, James, right?
No, he was here.
Oh, wait a minute.
Yeah, he showed up. There were several that I had called that weren't here that showed up within 15-20 minutes. All right, those names are going to be called loudly, distinctly in the courthouse. There's no response, and the court's going to issue judgment non-size and alias KPS and warrants for each of those individuals. Court will stand in recess until 1:30. Court will be broadcasted on